Well, folks, we got an update in the Colborn versus Netflix case filed yesterday. In defamation action, plaintiff Andrew L. Colborn asserts claims against 4 defendants who were involved in the production and distribution of 2 documentary miniseries, Making a Murder and Making a Murder 2. The case has been long stalled at the pleading stage, with a prompt resolution complicated by Colborn's initial delay in filing suit, waiting until just before the statute of limitations expired most of his claims. His further delay in attempting service is filing amend and second amend complaints. Defendants have not aided matters with their extensive motion practice, which has flooded the court with lengthy briefs raising dispute, factual, and legal issues against still undeveloped record. At this point, all defendants must move to dismiss Colborn's claims, but on 2 different bases. Defendant Lil Riccardi, Moradimos, and Chrome Media seek dismissal based on Colborn's alleged failure to serve them timely with the initial amending complaints. Defendant Colborn's Netflix Incorporate, which was served timely, seeks dismissal of the latest second amendment complaint as matter of law, based on various First Amendment defenses. Because the record established that Colborn promptly and timely served Riccardi and Demos and Chrome by publication, the court will deny their motion to dismiss. The court also denies Netflix's motion to dismiss as to all of one Colborn's claims, which Colborn neglects claim is bared by First Amendment. His defamation and intentional infliction of emotional distress claims are properly pleaded. The court will not accept Netflix's invitation to engage in fact-finding at the pleading stage of this case. Background. On December 18, 2015, Netflix first aided what became extraordinarily popular documentary series, Making a Murder. The series related events surrounding multiple criminal and civil legal proceedings involving Stephen Avery. As recounted in the documentary, in 1985, Avery was wrongfully convicted of raping a female jogger in Manitowoc County. After serving just over half of his 32 prison sentence, Avery was released with DNA evidence showed another man had committed the assault. Avery then pursued civil claims against Manitowoc County and 2 elected officials, the former county sheriff and district attorney, Tom Kushurk and Dennis Vogel, involved in the wrongful conviction. Amidst the litigation, a third legal proceeding erupted when Avery was charged with the murder of Teresa Hallbach, a young woman who went missing while on assignment photographing used cars for sale, including a vehicle for sale at Avery's residence. A jury ultimately convicted Avery of Hallbach's murder. His appeals from the second conviction have been rejected, and he remains in state prison. Making a Murder and his 2008 sequel, Making a Murder 2, purport of the documentaries depicting the events, including the flaws, failings, and triumphs surrounding these legal proceedings. Defendants insist that the original series and its sequel represent both sides of the events, albeit in a dramatic, entertaining way. Colborn argues, however, the presentation was biased and falsely depicts him as having framed Avery for Hallbach murder. As a result, he has been subjected to an onslaught of threats and criticism throughout the lawsuit. Colborn seeks redress from the defendants of the harm arising from allegedly biased false depiction. A. Colborn's efforts to serve complaint. Colborn filed his initial complaint in Manitowoc County Circuit Court on December 17, 2018, nearly 3 years to the day after Netflix first broadcast Making a Murder. The initial complaint claims 8 defendants, half of whom have since been dropped from the lawsuit. Colborn made no attempt to serve the initial complaint. On March 4, 2019, Colborn filed an amending complaint asserting claims that only 4 defendants, Netflix, Lil Riccardi, Moradimos, and Chrome Media, Netflix's streaming service and co-producer of Making a Murder series. Riccardi and Demos are the filmmakers and primary producers of the series. Chrome is a film production company owned by Riccardi and Demos. For purposes of the decision of the order, Riccardi, Demos, and Chrome will be referred to as filmmaker defendants. After filing the amended complaint, Colborn for the first time attempted service on the defendants. He had no trouble serving Netflix, which acknowledged receiving proper service on March 5, 2019. Serving the filmmaker defendants provide more complicated. On March 6, 2019, Colborn attempted personal service on Chrome through his registered agent, Tal Benari. Benari is employed as an accounting firm, R.C. Barrel & Company, which offices at 15 Ventura in Encino, California. An address to Chrome also lists the principal place of business. Benari was not present with the process service attempt service and Encino, California business address on March 6th and again on March 7th. Accordingly, the process server left copies of the original amended summons and complaints in the reception desk. Bernardi acknowledged receiving copies from the receptionist on March 7th or 8th. The process server also made 3 attempts, March 8th, 9th, and 12th, to serve Bernardi at his home address in Tarzana, California. The process server tried again to serve Bernardi in the Encino office March 15th. Bernardi denies being personally served May 2019. Colborn's process server also attempted to serve both Riccardi and Demos at Chrome's Encino business address. Neither Riccardi nor Demos were present at the address on March 6th. The receptionist told process server they were not Chrome employees. The next day, process server attempted unsuccessfully to serve them at their home in Los Angeles. Riccardi and Demos confirmed that serving them during this time period would have been difficult. Both were traveling away from March 4th, when an amended complaint was filed, through March 19th. Riccardi admits that she was finally returned home on March 9th, 2019. She discovered 2 large envelopes addressed to her and Demos containing copies of the pleadings. At this time, the efforts Colborn Counsel was exploring alternative service possibilities. Counsel served the internet for possible company speaking appearances by Riccardi and Demos. She also sought out possible film locations to check the dockets for. Appellate proceedings involving every case in hopes of finding a place where the server might be accomplished. None of the alternative efforts provided fruitful. When this efforts failed, Colborn elected to attempt to service by publication under Wisconsin law. Colborn filed a publication and summons, amended publication summons in the Circuit Court on March 11, 2019. The amended publication summons was published in the Los Angeles Times March 13, 2027, and April 3, 2019. On April 3, 2019, Netflix removed case in federal court in diversity and injunction grounds. On May 9, 2019, Netflix moved to dismiss the complaint under rule, arguing that Colborn had failed to plead a plausible claim of defamation. The next day, Demos regarding Chrome Media filed their own motion to dismiss, asserting that Colborn had failed to serve the properly and initially amended complaints. Colborn responded with substantive and procedural arguments to both motions. On December 19, 2019, the court had a telephone hearing motion to dismiss. Excuse me. After a long argument, the court denied Netflix's motion, concluding the amended complaint plausibly alleged a defamation claim. The court then granted Colborn's leave to file a second amended complaint. The court did not rule on filmmakers' defendant's motion to dismiss, and a later order concluded that the factual issues related to Colborn's service efforts required an evidentiary hearing. Before the court could conduct an evidentiary hearing scheduled for March 6th, COVID-19 pandemic hit, and hearing was postponed, later canceled. On January 3rd, 2020, Colborn filed a second amended complaint. He served the filmmaker defendants with the latest pleading, but argued that they did not need to respond until their motion to dismiss on the service issue was resolved. Netflix was also served with a second amended complaint. He responded with a second motion to dismiss, insisting that defamation claims, even if plausible, failed the matter of law. On September 21st, 2020, with the motion pending, the case was subject to judicial reassignment. Shortly thereafter, the court held a status conference, which questioned whether the evidence hearing was necessary. Given that the underlying facts concerning services effort were likely undisputed, the parties confirmed that the disagreements primarily related to the characterization of Colborn's service efforts rather than the actual facts of what took place. Accordingly, the court ordered the parties to file agreed upon statements, facts relating to the efforts of service continue the status conference for 3 months. At the continued status conference, the court heard reports on status of the case, took motions to dismiss under advisement. After ruling on other pending procedural motions, the court ordered the parties to mediate the dispute. Subsequent March 9, 2021, mediation before Magistrate Judge William E. Duffin provided unsuccessful. Colborn successfully served the filmmaker defendant's publication. The filmmaker defendants seemed to seek dismissal of the claims in the amended complaint based on insufficiency of service and statute of limitation grounds. They contend that Colborn failed to serve them timely with the initial amended complaints, with the result in the statute of limitations has expired, precluding Colborn from pursuing his claims against them because the relevant facts concerning service occurred before removal. Resolution of the motion requires analysis of Wisconsin state limitations of defamation claims and Wisconsin procedural rules governing service of process. In determining the validity of service in a state court prior to removal, a federal court must apply law to the state in which the service was made. Wisconsin has a 3-year statute of limitations for intentional torts, including defamation. To be timely under Wisconsin law, a defamation action must be commenced within 3 years after the cause of action occurs. When this summons and complaint are filed with this court, provided service and authentic copy of the summons and the complaint is made upon the defendant within 90 days after filing. Colborn claims against the filmmaker's defendants and original and amended complaints are based entirely on the original Make and Murder miniseries. The series first aired December 18, 2015, and the parties therefore agreed that Colborn's claims occurred on that day. To be timely, Colborn was required to file his summons and complaint within 3 years. By December 17, 2018, service and defense within 90 days of filing, March 18, 2019, parties dispute whether Colborn satisfied the second of these requirements. Service of the summons complaint under Wisconsin law governed in Wisconsin state. Generally, plaintiff must receive personal service on both individual and corporate, but Wisconsin law allows for service of publication and other methods of service cannot be accomplished with reasonable diligence. Colborn exercised reasonable diligence in attempting personal service. The filmmaker's defendants argue that Colborn was not entitled to serve them publication because he failed to exercise reasonable diligence in attempting the personal service. They note that Colborn waited until the last day before the statute of limitations expired for file his summons and complaint, which he then attempted to serve. They further complained that Colborn made insufficient efforts at personal service and amended complaint before proceeding the service to publication. According to the filmmaker defendants, by waiting until the last minute file and letting 77 to 90 days before even attempting service, Colborn failed to exercise reasonable diligence, making his resort to service by publication improper. Under Wisconsin law, whether plaintiff exercised reasonable diligence in attempting a personal service is a highly factual issue. In Houston, Wisconsin Supreme Court observes that even just 2 attempts of personal service may, under certain conditions, be sufficient reasonable diligence. In case court affirmed a trial court defamation in the plaintiff's efforts, which included just 2 visits to the defendant's home, same day is insufficient. The court noted, however, that the trial could have ruled either way in a reasonable diligence issue. Similarly, in the Hesslow, Wisconsin Court of Appeals affirmed the circuit court finding that the plaintiff had not shown reasonable diligence where the process served made just a single visit to defendant address, only to give up further personal service efforts after being told the defendant moved to Hawaii. Here, unlike the plaintiffs, Houston and Henley, Colborn shown to exercise reasonable diligence before resorting to service by publication. The record established Colborn process server made multiple attempts to process personal service and filmmakers defendants multiple locations. With respect to Chrome, the record shows Colborn's process server made 4 attempts to serve Benari, Chrome's registered agent, at his business address, once on March 6th, 7th, 15th. Also tried 3 times for Benari in his home address, 8th, 9th, and 12th, where while merely leaving copies of the pleadings with the receptionist was not effective service under Wisconsin law, the process server's decision to do so does not render his other efforts as personal service unreasonable or non-diligent. With respect to the recording demos, the process server twice attempted service on the office address designated for the production company, and he twice attempted service at their home address. The record also includes sworn statements from Colborn's counsel of her reasonable and diligent efforts to identify other locations for possible service regarding demos. Colborn's diligence is also established by counsel's sworn statement that she made the entire effort to hire a second process serving firm, even if that firm provided untrustworthy. While neither party has pointed a directly controlling case, the court is satisfied that the record of these various efforts demonstrates reasonable diligence under Wisconsin state law. As the Wisconsin Supreme Court explained, even just 2 attempts at the service can be reasonable diligence, and Colborn's efforts go well beyond meager efforts, which were found insufficient. Colborn's primary process server undertook multiple efforts to serve each of the filmmaker's defendants in the multiple locations and in multiple days. This in itself is sufficient to show reasonable diligence. Indeed, given Riccardi's admissions that she and Demos were traveling during this time, only an incredible amount of additional diligence would have resulted in a successful personal service. Further, counsel's additional efforts, hiring a second process server and the internet with the potential service location, pushed Colborn's efforts over the reasonable diligence. The burden of the service Unreasonable. Colborn expect to have time service after filing an amended complaint. Efforts he undertook have amended complaint were sufficient. The record established Colborn's service to filmmaker defendants by publication was proper under Wisconsin law. Filmmaker defendants also argue that Colborn failed to achieve proper service on these publications. They insist that Colborn's publication summons was insufficient under Wisconsin law. Colborn has not filed sufficient proof in attempts to personal service and filmmakers' defendants. Proof of publication fails to show proper publication of summons. The court rejects both arguments. Under Wisconsin service rules, service by publication both natural persons and limited liability companies requires publication of the summons as a Class 3 notice under blah blah blah, and mailing the summons and complaint to defendant's address. As Class 3 notice requires the insertion of the publication summons in qualifying newspaper 3 times. Contrary to the defendant's suggestion, the factual record of Colborn's service efforts is adequately supported. Colborn has provided declaration from process server, counsel, and newspaper publication notice. Collectively, these materials show Colborn satisfied the requirements of publication. Colborn has also filed copies of original amended publication summons, both of which will include the language required by the Wisconsin, likewise newspaper proof publication, blah blah yada yada yada. A filmmaker's defendants also argued that Colborn's service by publication was ineffective because the publication summons was flawed. They point out that the publication summons caption from the amended complaint includes only 4 remaining defendants and insist that summons was therefore insufficient. Argument confuses the difference between summons and complaint, especially in the context of service of publication, where service is made by publication. Wisconsin law requires plaintiff to arrange publication and publication summons, the contents of which was subsequently informed detail. The complaint itself not published in the course. Wisconsin does not absurdly require publication of entire pleading, which could file multiple newspaper pages. Rather, service by publication is intended to provide notice of existence of the complaint and lawsuit. Wisconsin law thus requires the plaintiff to mail copies of the summons and complaint to the defendant at or immediately prior to the first publication. Here the record shows that Colborn obtained published and publication summons from consistent with the Wisconsin state statute. He also presented proof that he mailed copies of original amendment complaints. Publication summons regarding the most quorum complied with the requirements of Wisconsin law. Colborn publication summons used updated caption of the amended complaint. There's no legal significance. Wisconsin law requires only the publication summons to be subsequently informed, detailed in section. There can be no question that the publication summons satisfy the requirement. Moreover, it would make no sense for the publication summons to have used the old suspended caption listing defendants who had been dropped from the lawsuit. Updated caption reflected the correct state of the parties at the time publication of service, and the filmmaker defendants did not point at any confusion or prejudice that could possibly be suffered by use of accurate caption, which include each of them while omitting other persons no longer being pursued in the litigation. Accordingly, even if the filmmaker's defendants were right and publication summons should use the original caption, and such technical error wouldn't affect the court's jurisdiction and require dismissal under state law. Requirements for the publication summons. Involved in a plaintiff who failed to serve her complaint in the defendant's 90 days filing resulted in state's limitations. Wisconsin Court of Appeals affirmed the circuit court's unsurprising ruling that plaintiff's subsequent filing service of an amended complaint could not resurrect claims for original complaint on which the state statute of limitations had run. Blah, 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 blah. Colborn has adequately pleaded defamation. Netflix seeks dismissal of Colborn's second amended complaint entirely on the First Amendment grounds. This is Netflix's second motion to dismiss. At December 19, 2018 hearing, the court denied Netflix's first motion to dismiss amended complaint, concluding that Colborn had plausibly alleged defamation claims. At this same hearing, the court rejected Netflix's argument that Colborn should not be granted leave to file a second amendment complaint, a copy which is attached to Colborn's motion to leave amend. The court explained that Netflix's arguments were misplaced and the motion to dismiss stage could properly raised and after discovery summary judgment. Despite the court early rulings, Netflix seeks a second bite at the dismissal of Apple. Its last motion and style. I don't understand the word these people like. I don't know. Motion style is motion dismissed, like throwing spaghetti at the wall with Zellner and then beating a dead horse. Now, taking a second bite of apple, whatever. The factual background of Colborn's claims: Netflix and court, the Colborn's defamation claims failed as a matter of law invoking a number of First Amendment offenses. At this stage, the court must accept all well-pleaded facts as true and draw reasonable inferences in the plaintiff's favor. To survive motion to dismiss, complaint must stay claims or relief to plausible on its face. A claim has factual plausibility when the plaintiff pleads factually conduct that allows the court to draw reasonable inference in the defendant's liability, misconduct alleged. In contrast, the moving party is entitled to summary judgment if he can show the absence of any genuine issue of material fact. The Second Amendment complaint alleges facts supporting a defamation claim under Wisconsin law. Under Wisconsin law, a defamation claim plaintiff must allege a false statement communicated by speech, conduct, or in writing to a person other than the person defamed. Communication is unprivileged and tends to harm one's reputation so as to lower him or her estimation of the community or deter third persons from associating or dealing with him or her. If the plaintiff and public figure, he or she must also allege, ultimately prove their clear and convincing evidence, actual malice. Actual malice means that allegedly defamation statement was made knowledgeable that it was false or with reckless disregard or whether it was false or not. As the court has already ruled in denying Netflix's first motion, rejecting Netflix's motion to Colborn's motion to leave, filed a Second Amendment complaint. His latest pleading adequately and plausibly pleads these elements, including actual malice. The Second Amendment complaint alleges that the defendants falsely led viewers to inescapable in conclusion that the plaintiff and other planted evidence to frame Avery for Hallbach's murder, omitted, distorted, and falsified material, significant facts, effort to portray plaintiff as a corrupt police officer who planted evidence to frame an innocent man. Colborn further alleged that the defendants committed this defamation, which actual malice, in order to make the series more profitable and more successful in their eyes of their peers, sacrificing and defaming character, reputation, and process. These allegations, and supported by extensive detail set forth in two attachments, legal inaccuracies, including altered clips of trial testimony, which Colborn contends present a false impression of his testimony and falsely put words in his mouth. Suffices to the state's claim of Wisconsin law. Having failed to convince the court inadequately of Colborn's allegation, Netflix shifts gears and offers a serious argument rejecting Colborn's claims as a matter of law. These contentions fail foremost because they are rife with factual assertions which require the court to make inferences, not flat-out factual findings, in Netflix's favor, turning the motion to dismiss standard on its head. The alleged defamation occurred in true crime. Documentaries do not constantly insulate Netflix from potential liability. Netflix portrays both Making a Murder and Making a Murder 2 as part of their venerable American tradition of true crime. Reporting suggests that the label alone renders defendants immune from defamation claims, but their argument obviously paints with far too broad a brush. Neither the Supreme Court nor the Seventh Circuit has suggested a speaker enjoys unconditional First Amendment immunity for making defamation statements simply because statements concern legal proceedings. Supreme Court held the First Amendment required public officials pursuing defamation claims against their critics to bear the heavy burden of establishing actual malice. While Justice Black urged the adoption of broader unconditional immunity along the lines Netflix now proposes, the majority of the Supreme Court has never gone this far. Moreover, the record remains undeveloped concerning the defendant's knowledge and actions. Whether Colborn can muster sufficient evidence for a jury to find that Netflix and other defendants defamed him with actual malice remains to be seen. But until the summary judgment record is complete, I would improper for the court to resolve this issue. Indeed, 2 of the 3 of the circuit court cases Netflix cites in support of the true crime argument. Remaining case, the 10th Circuit affirmed district court dismissal of defamation claims pleading stage but the appellate court decision offers little help analysis. The dismissal was based on the First Amendment, but the court conclusion of the defendants were statutorily protected from suit under the Oklahoma statute, which plainly no application here. Even the Wisconsin law attracted the Oklahoma statute, the 10th Circuit affirmation or summary does not help analyzing the sufficiency of Colborn's extremely detailed allegation under Wisconsin law. Netflix's insistence that Colborn defamation claim fails of a matter of law is based on Netflix's own and literal characterizations of the facts. Netflix argues that the dismissal is appropriate because reasonable viewers would not understand the documentary series to convey that the defendants, including Netflix, were asserting that Colborn framed Avery for Teresa Halbach's murder. Netflix insists that the allegedly defamatory statements identified as the complaint consist of subsequent that were accurate reporting of the defense theory in every murder trial. The argument cannot be resolved at the pleading stage. Whether the defendant's presentation of facts surrounding the defense theory was subsequently accurate, an early factual issue. Colborn plausibly alleges the defendant's portrayal of the underlying fact was substantially accurate, and that all he needs to do to the stage, indeed, assertion the defendant's intentionally altered excerpt from the Avery trial transcript would appear to undercut Netflix's substantial accurate claims. Likewise, whether a reasonable viewer might interrupt the series and complain that Colborn actually framed Avery is also an invariably factual issue. Colborn's citation of specific threats I've received from viewers strongly suggests that some audience members understood the documentary by accusing Colborn of criminal misconduct, leading to Avery's conviction from the Halbach murder. The resolution of these issues must, in a minimum, await discovery and summary judgment. In fact, Netflix's primary supportive argument in a summary judgment decision, the Seventh Circuit held that the district court properly granted summary judgment for various reports and news organizations, but only after a record had been developed showing that the defendant's reports show that September 2001 terrorist attacks was substantially true, providing an absolute bar to plaintiff's defamation claims. If the record and summary judgment established defendants' report that Avery was substantially true, they, like defendants in Global Relief, will be entitled to summary judgment, but that conclusion cannot be reached at this stage in proceedings. Finally, Netflix challenges Colborn's specific defamatory statements and likewise not the subject of religious emotion in the dismiss stage. It offers a disputed characterization of Colborn's allegations concerning the series portrayal of jail call, the dispatch call, the key, the various other admitted facts that are issues of summary judgment, or perhaps for a jury to resolve. The court cannot appropriately resolve them on a motion under rule. First Amendment bars Colborn's negligence claim, but not his claim for intentional infliction of emotional distress. Vast majority of parties briefing relates to Colborn's defamation claim, but Netflix also moves to dismissal of other two claims alleged in Second Amendment complaint. Colborn claims negligence, intentional infliction of emotional distress, both expressly incorporate an allegation on which he bases his defamation claim. Netflix argues that the First Amendment bars both of the alternative claims and contends that the public official plaintiff, like Colborn, must prove fault in excess of negligence, namely constitutional actual malice, to recover for any alleged injury concerning the challenged speech of expression as an emotional distress claim. Netflix contends that the First Amendment precludes all claims for intentional infliction of emotional distress permitted in speech about a matter of public concern. The court argues that Netflix Colborn's negligence claim is barred for the First Amendment. Fudge Miller Point, Supreme Court, New York Times, civilian ruling, the public official plaintiff bears a high burden in pursuing tort claims related to the publication of matters that are on public concern. To pursue such a claim, plaintiff must prove actual malice by clearing and convincing evidence. This requirement precludes any state law liability based on moral negligence. Accordingly, Colborn's negligence claim against Netflix is dismissed. Netflix challenged that Colborn's intentional infliction of emotional distress claim cannot be granted at the stage. However, contrary to Netflix's assertions, the Supreme Court has never held the First Amendment completely bars public officials' claims for intentional infliction of emotional distress. The Supreme Court held the public figure in the case, Jerry Falwell, was precluded from pursuing any emotional distress claims against the magazine for publishing an obviously satirical cartoon that was not reasonably believable. The court specifically confirmed that the public official could pursue an intentional inflammation and emotional distress claim based on publication, but only if the publication contains a false statement or fact which was made with actual malice. Right. Conclusion. The record established that Colborn properly served filmmaker defendant's publication. In addition, Colborn's Second Amendment complaint accurately pleads claims of defamation, intentional infliction, and emotional distress under Wisconsin law, but Colborn's attempt to pursue negligence claims against Netflix and other defendants is barred by the First Amendment. Accordingly, it is hereby ordered that the filmmaker's defendant's motion to dismiss is denied. It's further ordered that the Netflix motion to dismiss is denied as to Colborn's defamation and emotional claims, but granted as to negligence claims. Defendants are directed to answer Second Amendment complaint within 14 days of this order, dated May 26, 2021. Judge Ludwig. So, in 13 days, we will be hearing something. Not really good at reading things, so I apologize if I mess some words up. And this is my first time reading this, so any more updates in the Colborn case, I will let you know. I'm also going to post a link to this in the description, so if you want to read it for yourself, you can.